only if we talk about confidential proceedings as to Randy.
Understood.
Okay,
Understandable.
short of that, we're all
Thank you.
set and no problem there.
Thank you.
All right, so I have set aside 3 hours today to address the pending motions that we have in this matter, which are, Ms. Chris, your request to modify the parenting times so that you are, and a request for unsupervised parenting time with Randy Lee. And Mr. Howe, your request to relocate with Randy Lee to Indiana, and your objection there to that. So I have 3 hours. In essence, you each are entitled to 1.5 hours of that time, and I want to be mindful of the time to make sure that we each get enough time to present evidence and testimony of what you want me to hear today. I'd like to.
May I interject momentarily?
Yes.
The lion's share of time at the last hearing was allowed to Roland Howe for irrelevant and unsubstantiated issues. So this time, I would like it to be supported with evidence or not regarded, because we only have 3 hours.
So what I'd like to do is start with you. Your petition was filed first back in May of 2017. That means you're the petitioner and the moving party in your request for unsupervised contact.
Actually, in 2015, I asked for a modification of the court order, and I also made the court aware that there was alienation going on, and I also made the court aware of the goodbye letter I received, and nothing was done about that.
So I understand there was something in 2015. I see a dismissal of that. The only issue that's before me is your 2017 pleading.
That was disposed of based on, because there was a court order based on perjury, so it needs to be addressed. Because I have the evidence here today to prove that.
Judge Carver.
So I'm addressing your 2017 motion to modify and request for unsupervised parenting time.
They want to go over that first, they'll go over the rest of it after they go over the main ones first. They're working backwards.
I'm also going to address Mr. Rowland's request for the relocation. First, I'm going to hear from you, sir.
Mr. Rowland never gave notice to the court for relocation, so that shouldn't even be an option.
Ma'am, it is an option. It is noticed, and I am going to hear it. And I understand you object to it. I'm going to listen to your basis and your reason for the objection. Mr. Howe, rather. So once I hear from Ms. Chris on the request for unsupervised time, I'm going to turn to you and for your response on that issue. Neither of you are represented, so the court may have some questions of you that I may inquire because I need to get certain evidence in order to help me make a decision. So from time to time, I may interrupt with some questions that I have. So the burden shifts in the relocation piece. So after I hear sufficiently on the issues of your request, Ms. Chris, then I'm going to look to you, sir. And in the first instance, under the relocation statute, it's your burden as the moving party to that the move is for a legitimate purpose, and that the proposed location is reasonable in light of that purpose. So I'm going to hear from you on that issue. Then it switches over to Ms. Chris for her to tell me why she believes that's not in Randy Lee's best interest. What I will say is I understand, in general, many of the issues that are before us are the lengthy history of this case and that it's not just compartmentalized like I say that. But I want to understand there's different burdens here, and I want to be able to address both your objection to those things, and I need to hear your testimony as to the reason for the move and why it is that you're out there and why you believe that you should remain and Randy Lee with you. So we'll get to that when we do. All right? So.
May I?
Yes.
Okay. I have a copy of all the files we'll be referring to for you as well. We've already served Roland a copy of them as well. It's the entirety of the case from 04 up to 2017. We figured 18 was irrelevant because everyone already reached to get past those.
Okay.
I think my mother is allowing me with the opening statement. She'll continue with her own, but allowing me to start opening statement, correct?
No, actually, I am to make the opening.
No, I don't know. You're going to make her own statement. You allowed me to do a statement first before.
Yes.
Okay, thank you. That's all right. Hour and a half honestly seems a little bit more to really sum up this case. I mean, we're so familiar with it, we can sum it up probably in a half hour. In regards to your statement you had made to Roland just before I started talking here, you said that he has to provide an answer, reasonable doubt why he had moved to Indiana. Now, we had a confusion the last time we were here, as we had you on video stating that same thing to him and giving him a 30-day mark to make that reason. And your explicit words were, fear of Miss Chris is not a good enough reason. In fact, he'd actually tried opening with that statement before you set the 30-day mark. So, again, I understand you said last time we were all here, we weren't trying to solve the case in 30 days. No, we were not trying to solve the case in 30 days. But your 30-day mark was for him to provide reason. He still hasn't given that reason, so I'm interested to hear what that reason is regardless. But again, I just want to establish that fear of my mother is not the right example, correct?
Well, he can testify.
No, I get that, but I'm just saying that that's
Yeah, so
not a legal reason, I guess, is the wording I'm looking for.
I'll make the findings under the statute. He can
Okay.
tell me what he's going to about the basis for his move.
Okay, that's all I had asked for that. And then as just an opening statement in entirety in regards to the entire case, from what I've heard and from what I've been witness to this entire time, every time you've ever asked a question in regards to how Roland feels my mother is involved in Brandy's life, the only comments and arguments he's ever made without proof are a history of violence and drug addiction. Now, again, my mother did have a past of that consistency before she even got me back. Now, I returned to my mother at 14, which is the age of Brandy Lee right now. And she's had years of recovery and non-issues. And again, without proof, he's just made, unfortunately, bold claims. And there have been some things that she's been stubborn and ignorant about. As you can see, unfortunately, interrupting you is not the best case for any court case. But as you can see, it's an emotional turmoil that both of us have been going through. Within our documents that we're referring from here, I have years of examples of Roland missing out on visitations, usually coordinating with my mother's birthday, Brandy's birthday, holidays such as Mother's Day, Christmas, New Year's Eve. In fact, the year of the goodbye letter, which was 2015, we saw Brandy twice that year. He missed 9 of them, and the GNC canceled 3 of them for holidays. And it's just a repeat of that in every year that I have from the Greater National Visitation Center records. Yes, there's been 3 visitation centers here. Unfortunately, decisions about the situations that happened in these visitations have made without any side being put on ours. There was 3, the Manchester one, the Concord one, and the Greater National Visitation Center.
Can you get out that letter from the Concord?
Yes, I'll get that out in a moment when she asks for proof of it. The Manchester one only left because, unfortunately, there were issues with Roland's mother showing up, who was in favor of my mother getting guardianship.
So can I just want to kind of back up a little bit, okay? So I have looked at your file and have an understanding of the timeline as it goes there. But before we kind of jump into that, can I hear first from Ms. Chris on her petition, and then what I'd like to do is, if what you're doing really is testifying, I know you called it an opening statement, that's okay.
Okay, I got too much into that specifically. Just
fine.
basically I want to establish there's been no proof of any action that should keep my mother away from my sister.
Okay.
There's been no proof put forward, and I'm here to testify and prove with proof that that has never happened.
Okay, all right. So what I'd like to start with, Ms. Chris, is your petition for the unsupervised time. And so and you can, all of you too, Mr. Chris Chambers.
Just Cameron, if
Cameron,
you
thank you,
informal.
that's okay. If you can remain seated.
Oh,
please,
my
with-
apologies.
I mean, no, whatever you're comfortable with. And you too, Mr. Howe, if you want to remain seated, I want you to be comfortable. You're going to be in here for a little while. So, I understand from when I started sitting on this case in September, I believe, of this year, of 2017, that the background being that the National Visitation Center had terminated the supervised visits at that time. I also understand, and I want to hear from you about that position. I understand they are no longer in service at this point. I mean, we all know that they went out of business. But in any event, starting with that, if you would, and then as part of your testimony, you can tell me what you want to. But what I'm interested in hearing from you is what your request is of the court. You've asked for unsupervised time.
That's what she's asking for.
Okay, in the spirit of due process, I would like to make an opening statement.
I wasn't sworn in yet.
Oh, yeah, let's.
And I would
thank
like
you.
to be sworn in
All right.
as well as Roland before I do that.
All right, so I'll have you raise your right hand Do you solemnly swear or affirm that any testimony or information you provide to this court is true to the best of your knowledge and belief?
So help me God, I do.
Okay, and let me do you also, Cameron, separately. Do you swear or affirm that any testimony or information you provide to this court is true to the best of your knowledge and belief?
Under all of any gods, I do.
All right, thank you. Sir, you raise your right hand. Do you swear and affirm that any testimony or information you provide to this court is true to the best of your knowledge and belief?
Yes, I do.
All right, thank you very much. All right, go ahead, Ms. Chris.
Okay, I'm going forward under duress. I had asked for an extension. I was not provided with the rules of discovery. I was not provided with the provisions under the Americans with Disabilities Act to have reasonable accommodation. I was not given any of my discovery to prepare for this case. I also had a medical emergency where I had to go to the hospital for chest pain. And I asked you for an extension, which was denied. And also, I had asked you to recuse because you had not enforced the law regarding mandatory disclosure as well as parental interference. You gave him permission to stay temporarily in Indiana without giving notice to the court or following the orders of having her see the therapist that you suggested. And again, he gave you a name of Dr. Whalen. He didn't do that either. He also has a court order to provide health insurance for the child, and it says right in her school records that she did not have health insurance. Nor does he attend her IEP meetings. His wife does. Her school records state that his wife is her mother. Okay?
She still wants to know what we're asking for as far as...
What I'm asking for is for the court to follow the law. No sanctions have ever been issued. No contempts. None of it, nothing has, no kind of consequences have ever been given to Roland Howe. I would like to go back.
She wants to make it about the child, not wrong right now, okay?
No, I'm talking about his behavior,
No,
which
I know, but
prevents me from
she's-
seeing the child.
She's not asking for raise, she wants to know as a visitation. Summers and school
Excuse
vacations.
me, I'm testifying right now. As far as visitation goes, back in 2004, my parental rights were interfered with, and they have been interfered with throughout the duration of this trial with no just finding or cause, ever. I had a judge, Judge Barry, from 2004, recused in 2005, and rule on my case all the way through 2007. I even put in an emergency ex parte for safety for the child because his girlfriend, Melissa Philibert, that was taking care of Brandy Lee and cohabitating with him, was also working in my daughter's daycare, New Beginnings, with the full knowledge of all the members of this court and her court-appointed guardian, Barbara Griffin. And she lost custody of all 4 of her children to the state of New Hampshire. Meanwhile, I was being paid for unlicensed child care for the state of New Hampshire, and I was still deprived of my parental rights with no just cause or finding, and that has continued all the way through 2018.
Would you tell me if you would, the court has previously ordered that Brandy Lee only have supervised contact with you.
And there was no finding for that either.
So I'm saying in my review of the court orders, that is indeed been ordered by the court. What I'd like to hear from you would be helpful to me is, why is that not necessary now?
It never was necessary, that's why, and it was put in falsely, and those orders should have been vacated, and they weren't.
With Judge Barry being recused beforehand,
Anything after that should have been vacated.
because he was still signing the order.
It's fraud
and it-
upon the court is what it is.
And it
And
actually,
it's not being acknowledged, and it's not being enforced.
Judge Barry had actually made the signature that removed my mother from primary custodial parent. And he had already recused himself and had signed the order in 07. He was recused in 04 to 05.
There was never a
Technically,
finding-
everything should go back before that order.
There was never a finding for me to be supervised, no just cause to be supervised ever in these proceedings.
Now, I still believe you're asking for the question of what exactly details our visitation, what we're asking for with going forward. Our visitations, we understand that this is the environment that Brandy has been in her entire life. We are not looking to remove her from her siblings. She's in a 2-parent household. Not saying it's a good 2-parent household, but a 2-parent household is rare these days as
And
it
it's
is.
all she knows.
We do not want to rip her from that. We are not trying to change her life in a way that could harm her. We are merely asking summer vacations, school vacations, and we understand.
Holidays. Roland is a self-admitted atheist. My First Amendment right to worship as a family has been denied by this court and mocked repeatedly. And that is a constitutional right to worship as a family, and it's never been honored by this court.
Kind of like 3 octaves. Again, with that, we again acknowledge she's 14. At that age, especially with girls compared to boys, they mature at a faster rate. Now, again, we weren't privy to the conversation you had beforehand this case today with Brandy, but we feel if it's in this court's best interest towards her, that visitations of summer and holidays unsupervised with us, at least until the child turns 18, that way she can make a wholehearted decision. Again, her entire interaction with us, including since 3-year-old where cognitive memory actually starts, has been in a controlled, supervised environment. We were allowed outside for a point. It does seem that 2009 and 2010 records were missing from the Greater National Visitation Center records they had given us. Those are 2 years worth of records. I understand they had a flood at the time that caused a lot of this issue, but there still should have been some notation of it, but we have none of them. But again, that was during the time that we were leaving. The only reason that that stopped, where we had gone from semi-supervised to no supervision allowed to leave with Brandy from the visitation center, was because of one incident where, again, they told us we were unsupervised allowed to leave. My mother was in the car with her. I was behind in a company car. I just started a new job. I was on call. Now, they said that the reason is my mother can't be alone with my sister. There's never been anything
For no just cause.
There's never been anything established that she can't be alone with her or is in any danger around her. As well as, I was 19 at the time. I was in no way qualified to supervise a visit. How is that my responsibility when they're literally saying you're unsupervised allowed to leave the building with your mother and sister?
And it took years for Cameron to be allowed to come on these family visits, but now all of a sudden he's supervising them. And now when he stopped supervising them, now Roland doesn't want to allow him to talk to her on the phone when he had him supervising the visits. So he changes his mind at will to whatever pleases him, and this court co-signs it every single time.
Will you tell me the time frame again for that visits that you're talking about?